Good morning, all. We're here for the matter of an immediate judgment application before His Excellency Justice Omar and Muhairi in the matter of CFI 039-2016. The claimant is represented by King and Spalding. Lead counsel is Guillaume Hess. Assisting is Edward Perkins.
Your Excellency, good morning. We are here this morning to present to you the application made on the 17th of April 2018 by Passport Special Opportunities Master Fund LP, the claimant in this case and also the applicant this morning, seeking immediate judgment pursuant to the Part 8 claim for the recognition and enforcement of a money judgment issued by the High Court of Singapore. We ask that this court accedes to the applicant's application.
Excuse me to interrupt you here. I have some question before you proceed. I noticed from the paper and the application which you submit, you use a Part 8 and not Part 7.
Yes.
And you don't use Part 45 in regard to enforcement proceeding. Can you explain why?
That is a good question, Your Excellency. I have been brought on board this case at very short notice, and I did raise this issue with my colleagues. And the instruction we had from our client was to proceed with a Part 8 claim for the recognition and enforcement of this foreign judgment, and not a Part 7 or a Part 45.
Because the proceeding in Part 7 plus Part 45, this will be on paper. It's very speedy proceeding. Within 7 days, you will get, I can say, interim remedy order, which is you can take it within 14 days after service. It will be permanent order or permanent judgment of the IFC court, and you can enforcement within the IFC, outside of the IFC, or any other place through the MOUs.
Yes.
Or through treaties if the UAE is part of that treaty.
Yes.
So, for me, this is a strange situation. One. Second, to avoid a fee of the court, I'm not sure. Or you want to convert Singaporean judgment to the IFC court judgment, which is to enforce it within the Pakistani authority. Still not clear for me.
No, the intention, Your Excellency, is to have a recognition and enforcement of the judgment from the High Court of Singapore, and then to seek enforcement in Dubai onshore, in the UAE generally,
so,
not in Pakistan.
As in the IFC here, offshore, we don't have an asset, or still you're going to use Part 50 for investigation?
Exactly, that is the intention. Part 50 to investigate, to try to identify certain assets. We know that the second respondent, Mr. Iqbal, is present in the UAE from
So
time to time.
then if this scenario, if you use Part 45, will be much easier and less cost and time.
I agree with you. And I had a discussion yesterday regarding this matter, and when I presented this very question as to whether we shouldn't have used a Part 45 claim, there was no real answer or justification as to why we prefer Part 8.
So if you success for today application, then after you receive the immediate judgment, again, you will go back to the enforcement department within the IFC court and file 45 to be enforce our judgment.
Yes.
So you have to wait again to serve the judgment.
Yes. Yes. Preferably, I would agree with Your Excellency that we would have proceeded on the basis of a Part 45 claim for a speedier decision, but it was filed as a Part 8. That is why I'm here this morning.
Okay, go ahead. Just to wrap the case.
Sure. So we will ask that this court accedes to the applicant's application and grants immediate judgment, recognizing and enforcing the judgment issued by the High Court of Singapore against ARY Communications and Mr. Salman Iqbal, the two respondents in this application. The applicant seeks immediate judgment on the basis of Part 24 of the DIFC Court rules, and specifically Rule 24.1. Indeed, we will demonstrate that the respondents have no real prospect of successfully defending the claim, and there is no compelling reason why the claim should be disposed of at trial. Before we begin presenting the arguments in support of the application, we believe it would assist Your Excellency if we proceed with a brief background, a brief explanation of the background of the facts and the proceedings that have led us before you today. First, we need to go back to the arbitration proceedings that took place in Singapore. So very briefly, ARY Communications Limited, the first respondent, through its shareholders, defendants 2 to 6, in this claim, entered into an investment fund agreement with the applicant on the 15th of June 2008. Mr. Mohammed Salman Iqbal, the second respondent, is a director in ARY. A dispute arose under the investment fund agreement, and in accordance with the dispute provisions of that agreement, the applicant began arbitration proceedings in Singapore in September 2008, including against, of course, the two respondents in this application today. The arbitration was seated in Singapore, and the seat was determined by the tribunal, not decided by the parties. The arbitration agreement was pathological and did not provide for a seat of the arbitration. And the arbitration was governed under the Untitled rules, and the administering body, the appointing body, was the ICC. The tribunal rendered an award in favor of the applicant on the 2nd of February 2012, requiring all 6 respondents in the arbitration to be jointly and severally liable to all the amounts awarded. The applicant was unsuccessful in recovering any monies from the award, and at that juncture began enforcement proceedings in Singapore. The enforcement proceedings began in April 2015, and in the first instance, the High Court of Singapore issued an enforcement order on the 21st of April 2015. The order gave the 6 defendants 21 days to set aside the order. None of the defendants decided to set aside the order, and the High Court proceeded to issue a judgment on the award on the on the 6th of July 2015. And it is this judgment that the applicant is seeking to enforce in the UAE. In essence, the terms of this judgment...
So you take the track which to enforce a judgment, not to enforce the arbitral award according to New York Convention.
Precisely. So we are seeking to enforce this judgment, and this judgment essentially transcribes the content of the award, awarding $5 million plus a markup of 15.51% and additional costs arising out of the arbitration. The defendants, again, have failed to make any payments under this judgment.
But did they represented it there, or no one appeared before the Singaporean court?
They did appear. They did appear in Singapore. So despite several efforts to try to obtain payments from the defendants arising out of this judgment, no payments were made. And in a second effort to try to recover monies, the applicant sought enforcement of the judgment in Singapore in New York, in Nassau County, where the applicant obtained an attachment order and a judgment on the basis of the judgment in Singapore. But there again, unfortunately, the applicant was unsuccessful. And now, having identified a subsidiary of ARY Communications in Dubai, and knowing that the 4th defendant, or the second respondent today, is present in the UAE, the decision was to try to enforce the judgment of the Singapore courts in the UAE through the DIFC courts.
Using the memorandum of understanding.
Correct. Correct, yes. So once the applicant commenced proceedings under the Part 8 claim, there were several attempts to notify the defendants of the intention to seek enforcement in the UAE. And this was, we can see this in multiple correspondence. There were first about 20 attempts to try to serve the claim form and the particulars of claim, which all were unsuccessful. The applicant then sought to serve the court documents through representatives, legal representatives. None of them accepted service. And we finally obtained certificates of service in September 2017, saying that essentially service was properly effected on defendants 1 and 4.
After Justice Ali al-Madhani order.
This is, yes, exactly. So, His Excellency Al-Madani issued an order authorizing us to request immediate judgment. And in the order, the order essentially says that we were dispensed from serving the application today on the defendants, but we can also choose to do so by fax. We have attempted to do this by fax, and unfortunately the fax number did not work. And on that basis, we also attempted another way to serve the documents, including the hearing bundle, through their subsidiary in the UAE in person. And the person that we met in the offices refused service as well.
But through Dubai court, or when you serve to subsidiary, through Dubai court or through as a law firm?
No, through our colleagues.
No. But you don't have a certificate saying that the subsidiary refused to get.
I believe we tried to courier the bundles as well, and we do have a certificate showing that the parcel had been returned upon presentation.
But you don't use the email address to serve the application and particular claim.
I believe we haven't tried the email address. We had attempted the email address in the past, but these email addresses were equally unsuccessful. So we just tried fax and personal service at the location of the offices. And now for in brief, the arguments and supports of the application for the immediate judgment. So as I mentioned earlier, we are seeking enforcement under immediate judgment under Rule 24.1. And we will then demonstrate that the defendants have no real prospect of successfully defending the claim, and that there is no compelling reason why this claim should be disposed of at trial. On the prospects of successfully defending the claim, we submit that the defendants have no chance of being successful. First, because the respondents cannot dispute that the DIFC has good jurisdiction in this matter. And second, the respondents have no grounds on which they could possibly rely to oppose the recognition and enforcement of the judgment of the High Court of Singapore. On the powers of the DIFC courts, the applicant relies on the Judicial Authority Law, number 12 of 2004, and in particular Article 5A1E and Articles 7 and 6. The applicant also relies on the DIFC Court Law, number 10 of 2004, Article 24.1. Summarized, the DIFC Court has jurisdiction to ratify any judgment, order, or award made by a recognized foreign court. We also seek to rely on the Memorandum of Guidance on the enforcement between the DIFC courts and the Supreme Court of Singapore. The requirements under the memorandum for enforcing judgments of the High Court of Singapore and the DIFC courts are the following. And you will find actually a copy of this memorandum attached to the skeleton arguments that we have submitted.
Yeah, so before me.
Sorry?
Yeah, it's before me.
Yes, okay. So the memorandum applies only if the judgment from the High Court of Singapore is a money judgment. This is paragraph 1 in the introduction. Second, the judgment of the High Court of Singapore must be final and conclusive. That is paragraph 14 of the memorandum. And the High Court of Singapore must have had jurisdiction according to the DIFC rules on conflicts of law to determine the dispute. And that is paragraph 16. Now, if we go to the decision of the High Courts of Singapore in volume 1 of the bundle, behind tab 3, at page 31 and 32, So we will see that the judgment issued by the High Court of Singapore is indeed a money judgment. It is final and conclusive under Singapore law. And as submitted earlier, the High Court of Singapore had jurisdiction according to the DIFC rules because Singapore was the seat of the arbitration. Now, if we look at the memorandum, there are also indications of grounds on which the respondents, had they been present today, could rely on to defend the claim and possibly try to oppose our claim for recognition and enforcement of the judgment. If we look at paragraph 17, the respondents could allege that the judgment was obtained by frauds, or if the judgment is contrary to UAE public policy, or if the proceedings were conducted in a manner which the DIFC, of course, regards as contrary to the principles of natural justice. We submit that none of the above grounds exist in this case, and the defendants have given no indication that they wish to rely on any grounds listed or any other similar grounds to challenge the decision of the High Court of Singapore. Nor have they actually chosen to participate, once again, in these proceedings. Further, in the memorandum at paragraph 18, when presented with a decision from the High Court of Singapore, the DIFC courts will not re-examine the merits of the case, and it is reminded that the debtor of a judgment issued by the High Court of Singapore has a legal obligation to satisfy that judgment. The respondents have not. Instead, they have chosen to evade their obligation to satisfy their obligations under the decision of the High Court of Singapore, and have failed and continue to fail to make payments to the applicants. In the second prong of Rule 24.1, we submit that there is no compelling reason why this case should be disposed of at trial. In accordance with the memorandum, it is for the debtor of the judgment to establish any grounds on which they could rely on to challenge the enforcement and recognition of the decision of the High Courts. This is paragraph 17 again, but they have not. Not only are there no grounds to challenge the enforcement of the award of the judgment, there is no compelling reason why any presentation by the respondents, had they chosen to participate in these proceedings, could possibly challenge or change the factual and legal reality of this claim. The applicant obtained a final and conclusive money judgment from the High Court of Singapore, which had good jurisdiction to decide on the recognition and enforcement of the arbitral award. Further, and despite the applicant's best efforts to give the respondents an opportunity to challenge the award, to object or defend the proceedings in New York and in Singapore, or even present a possible defense today, they have consistently chosen to ignore the applicant and to evade service. We submit this demonstrates the respondent's continued intent to evade its obligations toward the applicants under the High Court's judgment, and had the respondents possessed any grounds for challenge, they would have no doubt been present this morning. They are not. Your Excellency, that is all for me this morning.
Can you take me to the final judgment or a certificate saying that the Singaporean judgment is final, which is issued on July 6, 2015?
I believe the submission that the decision of the High Court of Singapore is final is a matter of Singapore law.
Okay. Where I can find this?
I'm sorry?
Where I can find this?
I don't believe we do have a certificate.
You don't have a certificate. Only on witness statement?
Yes, witness statements, and we have the certified copy of the judgments.
Yeah, which is it's before me.
Yes, pages 31 and 32, correct.
Okay. Now the issue, actually the service. Can you take me again to part 9 and see your services comply with the part 9?
To part 9.
And what you say, you use the alternative method of service to serve an application and a particular of claim, but the defendants, both defendants, or in other saying, judgment debtors, they fail to attend. and you file certificate of service. That means according to Judge Ali Al-Madhani order, the service is completed. This is what you want to say about the service, correct? Or something else you miss? Or I missed something?
No, that is correct.
The total amount of the claim, actually, of the Singaporean judgments is 5 million US dollar, right? Or Singaporean dollar?
US dollar.
US dollar. And plus 15.5% per annum.
Yes, running from September 2008.
Yeah, September 15, 2008, until full payment. A quick calculation with the cost around 12 million US dollar.
That
It's roughly just a quick calculation.
Yes, yes.
So I need the exact amount you claim for until today.
Okay, until today.
Yeah, until just email it to the registry and they will forward it to me.
Of course.
Let's come to the format of the judgment now. If I'm going to issue a judgment, correct me if I'm wrong. So, are you seeking a judgment saying that converting the Singaporean court judgment to the IFC court, or just saying I'm recognized and grant to enforce the Singaporean judgment within the IFC? So this is two different things.
Yes, understood. What we are seeking is recognition and enforcement of the Singapore judgment.
And the only one judgment which I have is just we mentioned in June 2000.
The July 2015.
July of, let me double check. Yeah, July 6, 2015.
That
this
is
is
correct.
the only judgment you
That
are
is
looking
correct.
to be recognized within the IFC.
Yes.
So I'll try my best today to issue judgment. Otherwise, will be tomorrow. I will see the format I'm going to issue. Definitely, if you have any comments, you can comment before I make it as a final judgment.
Thank you.
You need to discuss about the cost of today's hearing.
Yes.
Did you submit a statement cost?
No, we have not. We have not yet. And I believe
How you want to proceed then?
we can submit the costs later today.
Okay. Or just mention in my order,
Yes, we can
today,
do that as well.
today's hearing costs will be on the judgment data.
Yes,
Something else you want to discuss?
that is all from your excellency.
Okay. Thank you.
Thank you.
Why is